everyone. Township of Edison Zoning Board of Adjustment special meeting is now in session. Adequate notice of this meeting as required by the Open Public Meetings Act of 1975 has been provided by the annual notice published in the Home News and Tribune on December 28, 2018, and has been posted in the main lobby of the municipal complex on January 4, 2019. Please join me in the Pledge of Allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Roll call, please, Cassandra.
We have a microphone.
Sorry, I don't have a mic yet. That's okay.
Thank you. Mr. Beatty?
Present.
Mr. Taglianetti?
Present.
Mr. Mansouri?
Present.
Mr. Shmuel?
Here.
Mr. Kamba?
Here.
Chairwoman Federick?
Here.
Jim Ayotte?
Here.
Ms. Shaw?
Present.
And Mr. Bignell?
And we have 2 members excused, correct?
Yes.
Okay. Want to read the first case, please, Cassandra?
Case number Z27, 2019, Ming Li Yen, 314 Pole Place, Edison, New Jersey, 08817, Section 37, 61, 5, 4, and 13. Bulk variances sought to add a second floor and expand the back of the existing single-family dwelling. Side yard required is 6 feet, proposed is 4.55 feet, which is existing. Front yard setback required is 25 feet, proposed is 18.5 feet. Lot coverage required is 23%, and proposed is 27.4%. Affected property is located in the RB zone, designated as Block 82B, Lot number 13A, on the Edison Township tax map. All paperwork is in order.
Who's going to testify? Okay. Would you raise your right hand? Do you solemnly swear or affirm to tell the whole truth, nothing but the truth, so help you God?
Yes, I do.
Please state your full name for the record.
Ming Li Yan.
Okay. Good evening, Ms. Yang. Will you please tell the board what you want to do and why, please? Bring the microphone closer to you, please, and speak into
Okay.
it loudly.
So my family, me, my husband, and my 3 daughters, the current house is a foreclosure by bank. It's not livable condition. It's completely not bearable to be living in. And since that is the case, we're going to knock it down and build a whole brand new structure of the house. And it's kind of very small, so it wouldn't fit a family of 5. And that's what we plan to do, is move in.
Okay, and just so the public is aware, we do have papers in front of us, and we do have a site plan. Does the board have any questions of the applicant? Mr. Mansouri?
Just to make sure, the applicant is tearing down the existing house and building something completely different.
You're not tearing down, you're adding to, correct?
Well,
You're going
we
to,
will, actually, yeah, well, the sidings and everything will be taken down, but we will keep the main structure, but then add to the back.
Okay.
And add upstairs.
okay.
Okay, so you're not essentially raising the building to the foundation and building another one. You're just adding, correct?
Yeah, we'll keep the skeleton, but
Yes,
the
correct.
outside material and stuff will be replaced with new materials.
Correct. Any other yes, Mr. Betty?
So in the rear of the house,
Boy.
I just want to make sure, in the rear of the house, you're extending the outside wall 2 feet back?
We're good at 15.7, going backward.
Well, it says 2 feet towards the top, right? On the front side, it says 2 feet. Is that a 2 feet extension of the entire wall?
I'm sorry, where are you seeing that?
In this area here. Right. Near the concrete driveway, on the left side of the concrete driveway, I see a 2 feet shaded portion.
That's going to be a window, a bay window.
Oh, I see. Okay. So the existing wall remains where it is, but a bay window will be cut out.
It'll be bent out.
Okay. Thank you.
Wait. I'm just testifying.
Oh, yes.
You were
can't
not sworn
testify.
in.
I'm sorry,
You
I-
want to respond. If you're going to testify, I need to swear you in.
He can tell me, right?
Okay, let me
Can I
have you
swear
raise your
into-
right hand. Do you solemnly swear or affirm to tell the whole truth, nothing but the truth to help you God?
Yes,
Okay, and what is your name stated for the record?
Con Yen.
Okay, thank you,
He
Mr.
has to repeat what he said.
Yes, and you now have to repeat what you said.
Oh, okay. The 2 feet's going to be a window, on the left side, that's gonna be a bay window.
Okay.
And just so it's of record, so the public knows and it's put on film, you have stayed under the FAR. And I'm assuming when I went out to see the house, if I'm looking at the house, there's a house next door to you on the right. I'm assuming your house will probably be as big as that house is.
It's gonna be identical, it's actually my house, so we're brother and sister, so now we're living on the same
Okay,
block next
so
to
it
each
will be
other.
identical to the house next door?
Yes.
Okay.
Madam Chair,
Yes, Mr.
I have a
Levon?
question. This is the site plan that you're submitting to the board, but you currently have a driveway that leads from your property line all the way to the back of the garage, is that correct?
Yes,
It's
Okay,
there
it's
right
not
now.
shown on the site plan here. So that driveway could put you over on lot coverage.
when,
And you might very well be over on lot coverage. We can't approve this drawing because you don't have the driveway as it currently is located on your property.
is it possible for us to remove that part of the driveway? That goes all the way
You
to the
can-
back?
Yeah, you can, to make it conform to what you submitted to us.
We're gonna go with the plan on what we submitted to you.
So we're going to put that in as a condition, that the driveway that's there currently, that's not on the plan, will be removed, so that the lot coverage will comply with the bulk standard. Right?
Yes.
Okay.
Does the board have any other questions of the applicant?
Madam Chair.
Yes, Mr. Comba?
Ma'am, have you received the Township Zoning Report Board Review Letter? It was dated September 16th, 2019.
I'm sorry, what is that?
It's the Township Zoning Report Board Review Letter? It was
Yes,
from the zoning officer?
yes,
Okay, and you're willing to comply with it?
yes.
Excellent, thank you very much.
Any other questions of the applicant? None? I'll go out to the public. Anyone within 200 feet of the property wanting to be heard? Anyone outside of 200 feet of the property wanting to be heard? There being none, I'll go to the board, please.
Madam Chair, I make a motion to approve. It's a benefit to the area. It's de minimis in nature. It's within the FAR. They will eliminate that driveway that would have put them over the lot coverage. That's it.
Do I have a second?
Second.
Thank you. Cassandra, please.
Mr. Beatty?
Yes to the motion.
Mr. Taglianetti?
Yes, the motion.
Mr. Mansouri?
Yes to the motion.
Mr. Shmuel?
Yes on the motion.
Mr. Kamba?
Yes on the motion.
And Chairwoman Federick?
Yes on the motion. Okay, good evening. You're done, and you're
Okay,
approved.
thank you very much.
Okay,
Thank you.
you're welcome. Cassandra, read the next case, please.
Case number Z46, 2017. Care One LLC, 1350 Inman Road, Edison, New Jersey, 08820, Section 3711-1, 3763, 1, 10, 11, 12, 13, and 16. Preliminary and final site plan approval being sought along with use and bulk variances to construct a new 90,000 square foot or 3-story assisted living facility. Max building coverage required is 15%, proposed is 16.8%. Max lot coverage required is 30%, proposed is 41.8%. Max FAR required is .25, proposed is .28. Max building height required is 40 feet, proposed is 47 feet. Max number of stories required is 2.5, proposed is 3. Affected property is located in the RA zone, designated as Block 410, lot numbers 27, 28, 30, 31, and 11C on the Edison Township tax map. All paperwork is in order.
Thank you, Cassandra. There's going to be a few housekeeping rules that I'm going to mention, but first, Jim, can you go get Mr. Kazarowski, please, in the hallway? Because I do want him to hear this also. I think that's him sitting right at the end of the hallway, but I can't see because there is something in my way. of vision. I know. He's trying to get the volume on the mics, and that happens, so I don't know. I don't know what's right.
How you doing?
Okay. Good evening, Mr. Gazarovski. Just before we get started, as you'll notice, what I said at the beginning of the meeting, we have 2 members of the board that are not here this evening. Under the rules and regulations that govern our meeting, when there's a use application, the applicant has the right to have 7 members to vote. So this evening, since the 2 members are not here, Ms. Shaw checked with Ms. Aram, and she does require a full complement of the 7 members for a vote. So having said that, we're going to resume where we left off at the last meeting. I'm not sure how long that's going to take. I'm not sure I'm going to get out to the public, because as I had said prior, when I go out to the public, it will be all in one night. I will not do part tonight and part another night, because anybody that is in the public will have one chance and one chance only to speak, and the only way that we can control that is having the public heard in one night. So if we get done early enough tonight, we will go out to the public, but there will be no vote. You'll have another meeting to come back for the vote. If it becomes too late, and I will not, again, go out to the public and split it, then the next meeting will be the public portion and the vote. Hopefully, we will have 7 members at that time. So having said all that,
My understanding is that where we are is that
microphone, please. There. Microphone and appearances. Your name?
Hey, how you doing?
Why don't you give us your name, who you're here for? And sir, I know you're not Don Aram, so after Mr. Gazarovski gets done, I will ask you your name, and we'll get appearances on the record.
Okay. My name is Ron Gazarovski. I'm an attorney with offices in Red Bank, New Jersey. I earlier identified myself.
We're having a little problem beside everything else tonight. You know, what else?
You okay with it now?
All right, try again.
I earlier identified myself as representing several objectors in this matter. My recollection of the sequence of events is that all that's left to be done for the applicant as well as the objector is that I'm going to cross-examine Mr. Phillips, who was the applicant's planning expert, and I think Ms. Aram's stand-in is going to cross-examine Mr. Steck, who earlier testified. That's my understanding of where we are, unless somebody recalls it different.
Sorry.
Good evening, Madam Chairman, members of the board. My name is Tom Troutner. I'm an attorney.
I'm sorry, the last name again?
Sure, Troutner, T-R-A-U-T, N as in Nathan,
Okay.
E-R. And I'm an attorney at Chiesa, Shaheni, and Gia Tomasi. I work with Ms. Aram, and covering for her this evening. My understanding in terms of the procedure or things that remain to be accomplished this evening from the applicant's perspective is that there was a question raised by Mr. Taglianetti at the last hearing regarding rooftop mechanical equipment and certain sightlines. So we would respectfully seek the opportunity to have Mike Pomerico come back and present limited testimony to respond to that issue. Certainly, Mr. Gazarovski has opportunity to.
I have no objection to that.
Certainly. I agree with Mr. Gazarovski that Mr. Phillips would testify. There is an updated fiscal impact statement and some additional cleanup that we wanted to have Mr. Phillips testify to, and then Mr. Gazarovski can complete his cross as to that, as well as any remaining cross that.
I don't believe I have a copy of that statement.
Well, hopefully we have one.
Okay.
And then last but not least, there's the cross-examination of Mr. Steck, and I believe Mr. Litwarnia may have submitted a updated, or a report for which we would seek some cross-examination and an opportunity to rebut
Right.
certain information in that report.
Yeah, I think Mr. Litwarnia had concluded his testimony, and then he submitted a report, and I would agree that the report was submitted after Mr. Litwarnia testified, and if he wishes to cross-examine Mr. Litwarnia, he should have the opportunity to do that. I agree with that. And I would take it, though, that before I cross-examine Mr. Phillips, you'll complete your applicant's case, and then I'll cross-examine Mr. Phillips.
Okay, I'm just going to be clear on this because we've had so many meetings. The applicant's case was complete. There was your cross-examination, but Mr. Phillips was unavailable, so you're going to be cross-examining and completing that cross of Mr. Phillips. Then the applicant will have the opportunity to cross-examine your experts, after which the applicant has the opportunity to have rebuttal testimony. There was in the interim a question raised by Mr. Taglianetti, which will be addressed first before that happens. And if counsel is, Mr. Trapner, what exactly did you need to present additional in terms of a direct testimony? Because as far as we were concerned, the applicant's testimony and case was complete.
So there is an updated fiscal impact statement that was submitted in October, or I guess that would be recently, to the board. And my understanding from Ms. Aram was that testimony needed to be completed on that, as well as which relates to tax revenue for that. And then Mr. Aram had suggested that there was a clarification question regarding the skilled nursing facility variance criteria. My understanding from Ms. Aram was that the applicant's case had not been completed, but that's, obviously I wasn't present. So.
I asked that question several times, probably at least one meeting ago, and the applicant's case was complete.
Okay.
So having said that, I do understand that you do have the right to have the updated fiscal impact study, which the board has for its review. I think you can address those issues after we complete answering Mr. Taglianetti's question, and then after that, Mr. Gazarovski can continue with his cross-examination, at which point you'll do your cross-examination and present any rebuttal information and additional information you need to complete. And then, if depending on the time, we'll determine whether we're going out to the public. And Mr. Gazarovski, I understand that if there is additional testimony to finish up, then you do have a right to ask questions with respect to that. So I understand that.
I just want to reserve my right to the introduction of that testimony when it begins. If we're talking in terms of taxes or fiscal impact, I don't know what relevance that has to getting a use variance. But we'll cross that bridge when we get to it.
That sounds appropriate.
Thank you.
Okay.
Okay, Mr. Tautner, then, will you bring up, did you say Mr. Palmerico?
That's correct.
To answer Mr. Taglianetti's question, let's do that first.
Great, thank you. Certainly.
This is new. This is highlights. Microphone, please, Mr. Palmerico.
I wasn't sure if I needed to be
Well,
sworn in again.
There's another one there that you can take off and carry with you.
Mr. Palmerico, even though you've been sworn in, I'm going to do it again, simply for the record. Do you solemnly swear or affirm to tell the whole truth, nothing but the truth, so help you God?
I do.
And state your full name for the record.
Michael A. Palmerico, architect.
Okay. And we still have your qualifications of record from the last however many meetings we've had.
Pomarico.
Mr. Palmerico, at the last hearing, Mr. Taglianetti had asked a question relative to the height of the parapet roof line at 47 feet. And I believe your testimony was that part of the reason for that height was for the parapet to screen the rooftop units that you had provided testimony to. And at the risk of paraphrasing Mr. Taglianetti, and hopefully he'll correct me if I'm wrong, Mr. Taglianetti wanted to know how high the rooftop units are and whether you could reduce or contract the parapet height to bring the roof height down. And I wanted to see if, did you prepare an exhibit to address that question?
Yes, I did.
And if you could, is that a schematic section line of site exhibit?
Yes. I'm going to mark this as schematic section line of sight exhibit.
I think that would be A43.
No, I don't think so.
Nope.
Cassandra, we're beyond A47, aren't we, or 48? I think I could be wrong, but we're going to find out.
Fair enough.
So it is A42, we don't have 40.
I have A42 as a real estate stack valuation report and underlying data prepared by Mr. Stack, if that comports with you.
Stand
Okay.
corrected.
No,
All right,
okay.
43.
All right, so A43. So, Mr. Palmerico, could you please describe what the exhibit, which has been marked as A43, depicts?
And Mr. Towner, bring that microphone a little closer to you, please.
Certainly.
So you're a little louder. And Mr. Palmerico, you speak up a little louder, please, also.
Yes. Okay, so this is marked A43, and should we mark the photos that I have on the back of the board as A44?
I think that makes sense, if that's...
Okay.
Okay, great. So we prepared a diagram to try and explain the sizing of the, you could call it a parapet, we're calling it a roof screen, really, because that's really what it's doing. So historically, when we've done projects like this in the past, we've always exercised caution when we do these roof screens because no one likes to be able to see rooftop-mounted equipment from the surrounding neighborhood. So that's why we've taken a fair amount of care to make sure that the design of the building conceals that equipment from sight. And on the drawing that we prepared, we have two sections, and each of the sections mirror the sections that were prepared by Langen Engineering. And you can see we have the 40-foot height of the building shown, and then we have the 7 feet of the roof screen shown above that. And if you look, you can see we've drawn on section east-west, the top section. We've drawn the equipment to scale, and on the bottom section, you can see where we've drawn the equipment on the roof to scale. And there's different pieces of equipment that are positioned in different locations on the roof. But if you look at the east-west section, you'll see the top of the air handling unit And, you know, you can see that from Lewis Court, because the people are closer to the building, the equipment is naturally obscured by the 40-foot line. But as one moves further away from the building, and what we tried to do is work with a range of around 600 to 800 feet from the building, so that anything or any person that's viewing the building within 600 to 800 feet of the building from a reasonable elevation, because the elevation does undulate around the building. King Street is a little higher than Lewis Court, and then as you go further out from Lewis Court, the elevations change and buildings get a little higher. And as you get further away from that, obviously the angle of inclination as you go further out increases the potential to see the equipment. So we wanted to make sure that after around 600 to 800 feet away from the building, there's so many other things that are going on in a person's line of sight: trees, houses, telephone poles, you know, all of the different things that affect the vision line. So we felt that that was a reasonably safe distance to set the parapet so that anyone that's within that range of the structure has no possibility of seeing the rooftop-mounted equipment. And then as you get further and further away from that, you'll incrementally see small amounts of it, but after 1,000 feet from the building gets to be so far away that those visual items are lost in the line of sight naturally. So, so that's what we were showing here. And so you can see the height of the parapet, the height of the rooftop-mounted equipment in each of the sections. I think the north-south section actually is very interesting, because from King Street you can see, because those houses are higher up relative to the site. So that angle of view, you can see that we're just obscuring the equipment. If we lowered the roof screen any lower, the people who are as close as King Street would start to be able to see equipment that sits on top of the roof of the building. So what I also prepared, because we're building another Care One facility in East Brunswick that is very similar in design to this building, and it's under construction right now. I didn't have this picture blown up large scale because it would have gotten very grainy. But if you look at the picture, you can see the structural concrete deck of the building, which is the 40-foot height. And when you're up on the roof and you look at this structure, you actually see, if you've ever been on the roof of a building and you see a roof screen and how they're built and what they look like, you see that it actually, it's very similar to how a roof screen is made. But what we've done is, instead of going and buying an off-the-shelf roof screen that looks just like a regular kind of metal screen, you know, we built it ourselves and are using roof shingles instead of like slatted metal panels, so that it's more harmonious with the neighborhood. We didn't want to introduce prefabricated metal roof panels to screen the equipment. It's much more effective if we use roof shingles to make it look more residential in nature. But when you look at it and you're on the roof, you can see it very much looks like a roof screen.
Mr. Taglinetti, microphone, Mr. Taglinetti.
The north-south section closest to the adjacent building, that's a rooftop unit up there, closest to the right, near the right-hand side?
That's a condensing unit for a split system.
Well, how high is a condensing unit for a split system?
This one here is, once we get past the dunnage support for it, the unit itself is probably about 5 feet high, 4 feet high. So we set the units on a dunnage frame because we have to be cautious.
Usually it's about 6 inches.
In the winter, well, in the winter when we get heavy snow on the roof, and if you get drifting, the snow obscures the unit and it's running, and then it prevents it from being able to have airflow around it, and then that can be problematic for the functioning of the system. So we have to get it high enough above the roof so that even if we have a blizzard and there's like 20 or 30 inches of snow, that unit can continue to function properly without failure.
So you're saying at that point, it's about 7 feet high?
Yeah, it's about 7, it's at least 7 feet. I don't have a, but just looking at it, it's about 3.5 feet to that point there. It's about 7 feet. We tried to have everything top out at that elevation. We didn't want to go any higher than that.
Okay, thank you.
Mr. Betty? Yes, go ahead.
Just following up on his question, the unit that you have on the top, on the left side, on the top,
Yes.
will that not require dunnage?
Excuse me?
Will that unit not require dunnage?
Well, that's a different type of system. So that's an air handling unit, and that sits on a curb system. But the fresh air intake on that, fresh air intakes that are up higher on the unit, and
Okay.
they come off the side of the unit. The condensing unit is more of a coil, and it has a fan that pulls air through the coil. So if we put it too low to the roof,
No, my question is, will that unit on the top will not require a dunnage? That's correct, right?
no, it doesn't.
will be curb mounted.
It sits on a rooftop curb.
Okay.
That's correct.
All right.
Does anyone else have any questions of Mr. Palmerico? No. Okay, Mr. Gazarovski, as long as Mr. Palmerico is standing there, do you have any questions of him? Pardon me? Yeah. Is the microphone on?
No.
Please put it on. Thank you.
I do have some questions.
Great.
Fine.
Okay, go ahead, as long as he's
With
standing.
regard to the exhibits that were presented, and one of copy of which was given to me, have they been marked in evidence or marked for identification?
Yes, we just did A43 and A44.
Okay. Mr. Palmerico, drawing your attention, if I may, to Exhibit 43, and more particularly, looking at the top of that exhibit where it says the partial east-west sectional view. You see that? Right
Yes.
below your
Yeah.
drawing. Right. Then below that, you have the partial north-south sectional view. And on the north-south sectional view, as well as on the east-west sectional view, you also have identified or shown a house. I would take it so that you can show what your angles are or what one would see in looking out the windows, correct?
Yes, these are the same sections that were presented by Langen Engineering in previous testimony.
Can you tell me, with looking at the site plan, in fact, what particular lot, whether it be 33 or 34, are you identifying in this example, if you know?
It's really more of a schematic and conceptual section. That
Okay.
We're trying to generalize all of the structures on the street.
Okay, saying that you're trying to generalize, would you agree with me that with regard to that generalization as concerns the first floor elevation of those houses, as I look at the plan and I look at CD 101 of the site plan, the elevation, first floor elevation of those houses is at ground level 120. Is that correct? You don't show it on that particular.
Yeah, we're like I said, it's more of a conceptual
I
section.
understand that, but when I'm looking at what has been marked into evidence, which is the site plan, and I'm looking at the second sheet, which is CD 101, simply called the demolition plan, when I look at the elevation for those two lots, it's at elevation 120. You'll accept that, my representation?
If it's on the drawing, I'll
Fine.
accept it, yeah.
So taking that as the benchmark, being at 120, and I'm looking at your exhibit for the east-west sectional, it shows the first floor top of slab it being at 136. So the first floor slab elevation of the proposed building itself is approximately 16 feet higher than ground level of the adjacent houses shown on Langen Court.
Like I said earlier, those elevations are constantly changing around the periphery of the site, right?
Well, no, I don't think they're changing. I think that,
Well, King Street is higher than Lewis, right?
Pardon
So King Street's higher than Lewis, so as you go around the periphery, that changes.
I understand that, but now I'm just drawing your attention to the elevations as shown on the east-west sectional for Langen. And all I'm saying is that on Langen, looking at the ground level elevation in that backyard, if someone walks out into their backyard, they're at elevation 120. And they would then be looking up and the first floor elevation of the proposed building is 136. So, you know, we're talking of a difference of elevations of first floor for the residential use and first floor for this commercial use is 16 feet before you even start figuring out how high the building is. And I'm not saying that it's incorrect to use that figure.
No, if that's the marked topography, that is.
I know. Look, I understand what the topography is, but this applicant is before this board seeking a use variance, and one of the questions is what impact will this building have upon the adjacent property? So looking at it from their elevation, and if you carry that elevation over, you've got to add 16 to the 48 feet in height of that building, and that comes out to roughly 64 feet. Going from their backyard, looking up, it's a height of 64 feet.
Yes.
Okay, now, let's talk about the plantings which you have there.
I thought we were talking about the roof screen
Yeah, we
here.
were just talking about the roof screening, correct. The plantings we've already did.
Pardon me?
We already discussed, you crossed on the plantings.
Yeah, but he's been called back and he's testifying, and
But
he's
we're-
testifying
but we're-
as to the
but
height.
Mr. Gazarovski, we're speaking only about the top of the building to answer Mr. Taglinetti's question.
Okay.
We're not going to go back and rehash
That's
all of
fine.
the
Would you?
prior
Well,
testimony.
that's fine. Would you agree with me that the top of this building is 64 feet above the ground elevation of the
Mr.
adjacent structure?
Gazarovski, I'm going to stop you. You know, in the interest of moving forward, you've had the opportunity to cross-examine on that exact issue. We've already heard the testimony, he's already agreed. So I think we can move off the same question and come back to some other questions if you have.
But if you look at this exhibit, he's just not testifying as to what the height of the building is, but this exhibit also shows what he is saying. The site distances are looking toward the building, showing the plantings. They are on this exhibit. Why could I not ask questions about those plantings?
Because the plantings have already been asked and answered. We've gone through that testimony. He was only called back for a limited purpose. You've already had that opportunity. The limited purpose he testified to right now had to do with Mr. Taglianetti's questions with respect to the rooftop. So let's move forward because that testimony's already been brought out to this board.
Thank you. Then I have no further questions of this witness, if in fact my cross is going to be limited to that one example.
Cross-examinations typically are limited to those items that are being testified to right now. Okay? Okay.
That's your ruling. I'll abide by that.
Okay, thank you. Okay, no other questions from the board? Okay, thank you, Mr. Pomerico.
Thank you.
Okay. Why don't now, Mr. Gazarovski, you finish your cross-examination, or start your cross-examination of Mr. Phillips. Is that correct, Mr. Tautner?
I believe he's partway through that cross-examination, but he is going to continue. Mr. Phillips, if you would raise your right hand, I know you've been sworn before. Do you solemnly swear or affirm to tell the whole truth and nothing but the truth, so help you God?
I do.
Thank you.
And Mr. Gazarovski, please, let's try and keep a direct question so we can get a direct answer. And let's hear a question just one time, please.
Thank you. Could we just clarify one thing? When I read the transcript, and maybe my memory is failing, but it identifies the person as being there when Mr. Phillips gave direct testimony as Mr. Riley. I think I was there that evening. Maybe I'm wrong.
Mr. Gazarovski, I don't have the transcripts here with me, and I can't necessarily assist
Okay.
anyone in presenting their position.
That's fine. Good evening, Mr. Phillips.
Good evening.
Mr. Phillips, with regard to this particular application, you have been retained as the planner, have you not?
I have.
And obviously, you've testified before many boards as well of courts of law as an expert in the field of planning.
That's correct.
Would you agree with me that all testimony relative to planning testimony is primarily based upon the facts of the particular application that is before either the board or before a court of law?
Yes.
Okay. Now, when were you retained to give planning testimony in this particular matter?
2017, I think you already asked me that, but
I think so, too.
Mr.
and it's hard
Gazarovski,
to
we're
remember.
trying very hard. I understand that this entire application has had several meetings, but we're trying very hard not to be repetitive.
I'm trying not to be repetitive. I'm
But
asking
that
you-
has been asked at least on 2 occasions previously.
My understanding was that I would be permitted to cross-examine this witness. And
You are,
I will
Mr. you are,
I will abide by your rulings and attempt to live within the parameters of those rulings, okay?
Mr. Gazarovski, that question's been asked and answered. Let's move forward, please.
Okay. Now, Mr. Phillips, in your testimony, I believe, in direct testimony, you testified that this particular facility had in fact received a certificate of need.
yes.
Okay. Can you explain to me what, as regards a assisted living facility, what a certificate of need means as compared to a certificate of need for a nursing home?
I don't apply for certificates of need, so I don't know the subtleties of the difference. Maybe someone else from the applicant can answer that, but obviously both require a certificate need from the state authorizing body.
But you're not familiar with the exact requirements for such a certificate of need, or whether there's a difference between a certificate of need for a nursing home as compared to an assisted living facility?
I am not familiar with the subtleties of the differences. I don't make those applications.
Okay. Now, going on with regard to the, let's say, we'll call them for the sake of argument, companion buildings. In years prior, there was approved a nursing home on the adjacent property, correct?
Correct.
And now, of course, there's an application being made for the assisted living facility.
Correct.
My understanding is that the number of residents in the nursing home is slightly lower than that would be proposed for the assisted living facility.
The proposal for the assisted living facility is 106 beds, and I think there are 122 skilled nursing beds, if my memory serves me correct.
Okay, so I was mistaken with regard to that. Now, do you know whether or not there's an arrangement that if a person is in the assisted living facility, that upon time passing by, he would be able to transition into the nursing home, or you have no thoughts about that?
Okay.
What do you mean by an arrangement?
In other words, when a patient or a resident goes into the assisted living facility, he may not, in fact, have reached that point in his health where he would go into a nursing home. Do you know whether or not there's any agreement or licensing or contracts which say that when that person in the nursing home, when the assisted living facility, health is compromised, he would then be transitioned into the nursing home? If you don't know the answer,
I
that's
don't
fine.
know any particulars about any contract. What I will say is that, and I agree with you, Mr. Gazarovski, there's a logical transition. If a resident of the assisted living facility basically becomes too infirm and requires skilled nursing, then obviously there's the opportunity for that individual to transfer from assisted living to skilled nursing. But other than that, I don't know anything about any
That would be if
particular
there's
contract.
availability, correct?
Okay.
Absolutely.
Okay, now,
Oh, excuse me, Mr. Phillips, Mr. Gazarovski. Can I ask what you're trying to get at? Mr. Phillips is a planner. I just don't see the connection with why you're asking the planner what the interactings of a facility, one facility is with another.
Well,
He is the planner.
one
Am I not correct? He is the
of the
planner.
things that he is testifying,
Oh, we lost you.
pardon me?
We lost you. Go ahead. We
One of the
lost you.
things that he has testified to is, number one, that there's a need for this assisted living facility. He's showing the burden that he has to sustain in order to be granted this use variance, and I think all of that information is pertinent. And it may be, Madam Chair Lady, that you may not think it is, and if you want to rule that it's not and forbid me from asking that question, then you could do that.
Okay, well, ask it, and let's keep moving on, please.
Well,
Up, again. What
That's
is
fine.
that?
Can you read the question back? I forgot what the question was. Or I don't think there was a question. I think that you
it was
had,
Mr. Phillips,
I think I just answered the
you
question.
answered it,
Right.
correct.
okay. I'll skip over that, we'll keep on going. Now, during the course of your testimony, you testified both as to the master plan, did you not, which I believe was in 2003, as well as the reexamination report, which I believe was in 2011, correct?
Yeah, it's dated 2011, but I think as Mr. Bignell mentioned for the record, it wasn't adopted until 2013.
Okay, assuming that to be so, which I'm sure Mr. Bignell is correct, do you know whether or not since that date of 2013, there has either been a new master plan which was recommended by the planning board or a re-examination of the master plan, or is the last action by the planning board in this matter in 2013?
That's my understanding.
And my understanding is, with regard to such a plan, master plan, re-examination plan, while they may be authored by the planning board, they are in fact adopted by way of an ordinance by the governing body. Pardon me?
You've asked me this question before. I don't want to belabor this, but I'll give the same answer I gave. The master plan is under the sole jurisdiction of the planning board.
I acknowledge that.
The governing body may or may not choose to follow the recommendations of the planning board in terms of the master plan. The governing body has sole jurisdiction over zoning. And that question was asked of me during the prior cross, which you didn't finish, but just for the record.
Well, but just, I don't know why this is really, and I don't want to make it complicated. Would you agree with me that both the master plan and the re-examination plan have been adopted by the governing body in the form of an ordinance and have not been changed since the year of 2013?
The governing body does not adopt a master plan.
They don't adopt a master plan, they pass an ordinance, and they either have to adopt all of the findings of the master plan or disagree with them and so reflected in an ordinance. Correct?
Are we engaging in legal argument? I'm not entirely sure the direction of this examination. The board is aware that the master plan was
Fine.
accepted in 2013. So
Let me try to make it simpler. What is the
Please.
zoning for the subject property, Mr. Phillips?
The property's within an RA district, which is primarily a single-family zoning.
Okay. So the property is basically zoned for residential use. There is nothing in the existing zoning for these 3 lots which permits the construction of an assisted living facility. That's why you're here for a use variance.
That's why we're here for a D variance.
Okay, fine. Now, did you also testify when the nursing home came before this board, before a site plan approval many years ago?
No, I was not involved in the 2000 application.
Now, I think in your testimony on page 46 in line 6, you say that not all assisted living facilities are inherently incompatible with single-family homes. Now, are you aware of any assisted living facilities in the township of Edison or in an area within 10 miles of the parameters of the township of Edison where you think there is an assisted living facility which in fact is compatible with residential homes?
Yes, there are 3 assisted living facilities, as I mentioned in my direct testimony, and in all instances along the perimeter of those facilities, there are single-family residential neighborhoods, at least abutting some portion of those 3 tracts.
Now, are you aware of whether or not when those assisted living facilities were approved by whether it be the planning board or the zoning board, what the zoning was for that property?
I may have that information. Yeah, I know the zoning of the 3 assisted living facilities in Edison. What I cannot say with 100% certainty is whether that was the zoning at the time they were approved, but I do know the current zoning of each of those 3 facilities.
At the present time?
Correct.
Okay. Now, with regard to those 3 facilities, did you do any type of comparative analysis of the nature of the residential homes that surround that facility?
When you say a comparative, other than acknowledging that and confirming that there are abutting single-family residences, in all instances, I didn't really do any other further comparison or analysis.
Okay. Now, you mentioned that one of them was in Edison. Where are the other two located?
They're all in Edison.
They're all in Edison. Now, with regard to the project in question, I believe on page 45, line 12, you say that the project has been designed to have more of a residential feel. Now, the other one's not, okay. Now, is it your opinion that anyone driving along Inman Avenue is going to think that the proposed facility for this assisted living home is a large, single-family house?
No.
Are there any houses in the immediate area that are comparable either in square footage area or of similar height?
Not to my knowledge.
Okay, so then, having said that, what is it in your mind, in your opinion as a planner, that if you're driving along Inman Avenue, that the proposed facility will have the feel of a single-family residential home?
Well, I didn't say it would have the feel of a single-family residential home for the record. What I said was, and I was echoing and mirroring the testimony of the project architect, that the building was designed to have a residential feel.
Okay.
And that would be things such as the non-flat roof, the varied roof line, the pitch in the roof, the fact that there are changes in the facade plane, and also the issue of the materials that were used.
Did you ever take the time to count the number of windows that face the residents who live on Lewis Avenue? In other words, the windows that are on the first, second, and third floors of the proposed home, proposed assisted living?
I never counted them, no.
Never counted them. Would you agree with me that in a facility such as this, assisted living facility, that for a great part of perhaps the evening hours, this will be completely lighted up, lit up?
What will be completely lighted up?
Well, the windows which are showing off onto the Lewis Avenue site.
Well, I assume by lighted up, you're talking about in nighttime, and at nighttime, residents basically have blinds or shades to block that light outward?
How do you know that?
How do I know that?
Yeah.
That's my presumption, that
Okay.
there will be certain, those units will have the ability to have privacy, and one of the ways to have that privacy to the external world is through shades or blinds or some kind of similar window treatment.
Okay, now, would you agree with me that and you listened to my question of the architect with regard to the grade elevations of the proposed building as well as the grade elevations of the existing residential homes. Would you agree with me as a planner that the proposed assisted living facility is significantly on a higher plane or elevation than the existing one-family residential homes?
I would agree that I think at the maximum difference in the grade elevation, I think is the 16 feet. In some cases, the difference in grade is lower. It may be roughly 11 or 12 feet, but at maximum, it's 16 feet.
That's on the Lewis Avenue side?
Correct.
Well, the plan obviously speaks for itself, correct? Now, as a planner, I take it that one of the things you took into consideration is the buffering area and the use of materials in that buffered area, correct?
Yes.
Okay, now, can you tell me, if you know them, the species of the trees to be planted and at what height they'll be planted out when planted, and what the anticipated growth pattern is of those trees or shrubs?
So I don't know the particular specifications other than the testimony, as I recall, was a mixture of deciduous and conifer plantings. And my recollection in terms of the heights is that the goal was basically to screen at least half of the building from view at planting, and then obviously that those plantings will grow over time. And I seem to recall the testimony by our engineer who testified as to the landscape plan is that after 5 years, much of the upper floor would be screened to the homes on Lewis Court, and just the roof line would be visible after 10 years.
Well, if the grade elevation for the Lewis Court properties is 120, and the grade elevation for the proposed building is 136 or 16 feet higher, that would mean that every planting being planted would have to be at least a minimum of 16 feet high, would it not?
No, it wouldn't, because you basically have a perspective which would be shown in the sightline analysis from the point on Lewis Court, basically as the property rises to the assisted living facility from that sightline. And again, I'm not sure at what height. Again, my recollection of the testimony is those plantings basically would basically screen roughly half of the building at planting, and then they would grow to screen the upper floor.
How high would those plants have to be when planted to screen one half of the building?
Whatever's shown on the planting list in terms of the heights, I just don't recall.
I don't see that on the exhibit that was just given
I'm
to me.
sure it's on the landscape plan.
Okay. Now, how about with regard to the surrounding area of this property? Is it not so that each and every lot that's abutting this property on Lewis Court is a one-family residential home?
Yes.
And wouldn't you also agree with me that those properties to the rear of the property is also a part of a one-family residential home?
Yes.
Would you also agree with me that all of those houses, whether they're on Lewis or the other, are rather upscale in nature, meaning valued in excess of $300,000 to $400,000 per home?
I did not look into value, so I cannot answer or address that question.
Well, wouldn't the nature of the
They seem
surrounding...
to be reasonably well-maintained and kept, but I have no idea what the values are.
Well, wouldn't the fact that the property is surrounded by homes such as that have an impact or be impacted by a building of this size and magnitude?
I think from a planning standpoint, impacts on residential basically those impacts would be viewed whether those houses were luxury or sold for $1 million, or whether they sold for $500,000, or whether they sold for $250,000. To me, that's not material. The issue is whether or not those impacts, again, in the context of an inherently beneficial use, rise to the level of being substantially detrimental. That's the test. It doesn't really have anything to do with what the homes are valued at.
Okay. Now, when you looked at this project, did you also examine the outbound parameters of the survey of the three existing lots?
When you say I'm not quite sure I understand
Okay. The subject property consists of three lots, does it not?
There are 3 lots, yes.
Right. And all of those lots have some frontage on Inman Avenue.
Correct.
Okay. Now, would you agree with me that given the fact that there are one-family residential homes to the right, one-family residential homes to the left, that property itself would also lend itself to being developed?
There aren't one-family homes to the left. There's a skilled nursing facility to the left.
If I misspoke, I misspoke. One-family homes to the right, correct? One-family homes to the rear?
Correct.
And a nursing home to the left, which is zoned for that use, but the subject property is not. That's why you're here.
Well, it's not zoned for that use, but everything else you said, I would agree.
Okay, fine. Now, would you agree with me, though, then, that if, in fact, the property in question is zoned residential, it's adjacent to a residential use, and it is in front of a residential use, that the natural basis, with no hardships whatever or difficulties, would be to create a one-family residential complex there with one street going in off of Inman Avenue with a cul-de-sac? That could be done with no variances. You'd be before the planning board, wouldn't you?
If you're asking me whether those lots could be used for single-family as they had been done in the past, or someone could put in a cul-de-sac and meet standards, sure.
Okay.
It can be used for single-family. That's what it's zoned for.
Okay. Now, let's just talk a little bit about Inman Avenue. Now, you're aware of the fact that on the properties to the left, which would be the nursing home properties, as well as the properties to the right, which is where the one-family residential complex is, there has in fact been a road widening dedication to the county of Middlesex. That's shown on the plans, is it not?
I don't recall whether it's shown on the plans.
You want to take a quick look? Will you accept my representation that it is?
If you're representing it, I would accept that representation.
Okay, fine. Now, in looking at your plan, in preparing your testimony, did you give any consideration to the fact that well, first, let's go back a step. As of this date, this particular application has not been submitted or applied to the county planning board, has it?
I don't know whether, I don't believe it has county planning board approval. I don't know if there was any preliminary meetings with the county. I think other witnesses testified to that.
I accept that. But would you agree with me, though, that if in fact there's road widening to the left and road widening to the right, the chances are more than likely when this matter goes to the county, there will also have to be a dedication for road widening on that side of Inman Avenue.
I have no reason to either confirm or deny that. I don't know.
Okay. Would you also agree with me that a portion of this property is actually in the right-of-way of Inman Avenue?
Yeah, I think you asked me that at the, when you did prior cross. I think there's a small sliver that we saw in the tax map.
Okay. Now, when you give consideration to your determining floor area ratios and percentile of lot coverage and site distances and all of that sort, did you give it any consideration whatever to the concept that there will have to be road widening?
Well, I didn't give consideration to site distance. That's the engineer and traffic engineer, and I think they testified to that. With regard to the issues of zoning compliance, I believe the appropriate standard is the property as it exists today in fee simple ownership, and I believe that's what our engineer calculated in terms of FAR and coverage and everything else.
What is your opinion if, in fact, this matter goes to the county and the county demands that the road itself be widened, which would change site distances and change square footage of the lots and the like? Do you think the applicant would have to come back to this board for a reapproval?
No, I don't.
Could that be the reason why they're coming here first and going to the county second?
I have no idea. I don't get involved with the county.
In coming to your conclusions as a planner as to the appropriate layout of the site, are the site distances for the ingress and egress a part of your consideration?
It's obviously an issue, but it's not my issue. It's an issue for the traffic engineer, and I think, as I recall, that's been testified to. They have to be adequate and safe, but I don't get involved in that aspect of the site plan.
You don't think that's part of planning?
In its broadest sense, it is, but again, I'm not the person that testifies as to the adequacy.
Okay.
And I think we have testimony on the record, as I recall.
If in fact the road had to be widened and the setbacks were changed and the square footage would change, you don't think that's part of planning?
I think that it's really more an engineering issue than a planning issue, to
Well,
be
obviously,
perfectly frank with you.
obviously it's an engineering issue as far as determining what those numbers are, but isn't it a planning issue to see whether additional variances for setback and or the like may be necessary?
I've already testified that I don't think there would be additional variances.
Okay. With regard to the testimony you gave at line 48, you refer to the fact that consideration was given to the residents on Lewis Court as to not having parking in those areas adjacent to the residential properties. That was your testimony, was it not?
Correct.
Okay. So having said that, and despite that, you still have placed the generator and the refuse collection, I think, adjacent to those residential lots, correct?
I didn't place it there. That's what's shown on the site plan before the board.
Okay, but well, you didn't place them there, and you also did not locate the parking there, but they are also, in fact, areas which are immediately adjacent to the residential uses, correct?
Well, they're on the side of the building that's closest to the residents on Lewis Court.
Okay, now, I take it that you feel that the presence of parking in that area adjacent to Lewis Court would have an adverse impact upon the residents of Lewis Court. Was that the basis for your testimony?
No, it's not. What I said is that the parking basically creates a certain amount of on-site activity that's outdoors. And I think putting it on the opposite side of the building is more deferential from an impact standpoint to the residents on Lewis Court.
Okay. Now, having said that, would one of the issues with regard to parking, particularly in the evening hours, be light pollution from the various headlights and the like of the cars?
Lighting in a parking lot during the evening is a potential concern impact. Yes.
Well, isn't that the same concern that one would have with all of the dozens of windows which face off on Lewis Court as well as on the adjacent
I
property?
think we've been down that road.
Well, down the road saying you're going to in some way block it out with, I guess, air raid curtains or something of that sort, but you have no knowledge of it. Now, you also talk about the setbacks being greater than are required in the zone. Would you agree with me that historically, setbacks for residential homes, front yard setbacks, side yard setbacks, and the like, are lesser in dimension than they would be for a commercial zone?
That's fact sensitive. I can't make that generalization.
Well, in making the generalization,
You may have a commercial zone that has street wall buildings with zero setback in a downtown area.
Well, let me ask you this. You consider this to be a downtown area?
In a vacuum.
One person at a time.
Yeah,
And
you make
again, Mr.
reference.
Gazarovski,
I
please,
apologize.
let's move this along. I really would like to finish all of this tonight, so by the looks of it, I don't know about the public, but I really want to get all of this crossed on tonight. So please move it
Madam
along.
Chairman, I don't wish to offend you and/or the board.
I know, but you are,
But I don't
so
th-
please
I-
move
I
it
am
along.
offending you?
I'd appreciate it.
Okay.
And one person speaking at a time would really be nice for this young lady to be able to take down the notes
Okay.
also.
I accept your criticism of me, and I'll go on,
And I apologize to the young lady as well.
as do I. You mentioned the fact that in some instances, there's zero-line setbacks, and that's in a downtown area. Well, this is not a downtown area, is it?
That wasn't the question you asked. No, it's not a downtown area.
This is, in fact, an area that is zoned for residential use and immediately adjacent to residential uses.
Mr. Gazarovski.
Is that a
I think-
question
I
or
think
is
the
that a
board-
statement?
I think the board is aware that that is why they're here for a variance application.
You know what, I
We're aware.
appreciate.
Can we please, it's a question,
Yeah.
we know what the zone is, we're familiar with it. I think the board has heard that testimony throughout.
You know,
So let's move
I
forward.
appreciate, and I do think this is a very knowledgeable board, but there's
That-
also such a thing as creating a record, and that's what I'm doing.
And sir, that sounds like summation as opposed to asking a question. So let's get to the question.
I'm almost through.
Thank you.
In your opinion, as a planner, in order to satisfy the setback requirements for a building such as this and a use such as this, as compared to the adjacent residential uses, should the setback requirements be greater than those of a residential zone?
I believe that they should be greater, and in fact, they are greater in this instance, as I previously testified. We're probably 6 times the required setback in the side yard and twice the required setback in the rear yard.
Okay. When you looked at the plans, did you also give consideration as part of your planning testimony as to the floor area ratio of the buildings as compared to the overall site?
Yes, I testified as to the FAR variance.
Okay, now, in testifying as to the FAR variances, did you utilize all of those properties that are either in the right-of-way of Inman Avenue or might possibly removed from the site as a result of a road widening required by the county?
I did not include any land that could be part of a dedication to the county, as I've testified. And the small sliver of the current right-of-way that may be part of the property in terms of the calculations at FAR, I'm assuming that that was in the total land area, but the engineer did those calculations, but I'm assuming, since that's part of the lot, that that was in the calculation.
Okay, just a couple more quick questions. Prior to your coming here, and as a part of your preparation, did you also review the prior site plans and engineering plans and/or the engineering plans for the previous approval of the nursing home?
I only reviewed the prior resolution of approval from 2000. I did not review the plans.
Okay. Do you know whether or not on those plans there was any reference to wetlands being on the plans that encompassed the nursing home?
I did not review the plans, so I can't answer that question.
Did you make any attempt to consult the estate maps to see whether or not there's a reflection, or the county maps to show whether or not there's a reflection of wetlands being on the subject property?
I'm sorry, which maps? Estate? Which maps?
Just bear with me for 1 second. Okay. I'm sorry, Mr. I don't want to proceed without him sitting.
Go ahead, continue.
Go ahead.
Please continue.
Go ahead.
Are you okay if I proceed at this point? Okay. Mr. Phillips, in preparation for your testimony today, did you have any occasion to view the NJDEP GEO website with regard to showing whether or not there... Let me speak more slowly. Prior to your coming here this evening, did you have occasion to view the NJDEP GEO website to reflect whether or not there are possibly wetlands on the subject property?
No.
Okay. I'd like to have marked as objector exhibit for cross-examination this document.
Mr. Gazarovski, do we have copies for the board or no? Or is this the only one we have? If you could use the microphone, do we have copies for the board or is this the only one we have? Okay.
Do you have copies, Mr. Benton?
And is this, what exhibit is this? Is this objector 1?
I don't know what the number is. What do they call it?
Do we know if we have any other objector exhibits?
Yeah, there are, I think. Which you might want to just call this 1A?
Do you know? I don't remember getting any
So this may
either,
be
but-
the first from the objector.
I don't have any indication of
So I'm
objectors.
just
This may
going to
be the
mark
first
this
from
as
the
objector
objector.
1. So this is my copy? Do we have for the board?
Yeah.
Sir, are you
copies.
giving? Okay. I'm sorry, what are we doing, 01?
This is going to be 01. You've gotten other exhibits that, have they been disseminated to the board? Just Mr. Litwarnia, right? But that was not marked as an exhibit because that came in after. Okay. So this is 01.
Okay.
I'm sorry, may I just take one additional?
No, I got,
He needs, you need an additional one? Can you
let's
give
see,
him one?
are we okay? Let's make sure we have enough
He needs one to
Okay.
ask questions.
from there,
One,
here,
two.
and there. Okay.
Okay, Mr. Phillips, you've practiced planning in the state for many, many years, have you not?
I have.
Are you familiar with the New Jersey Department NJDEP website?
I am.
Okay, let me show you what has been marked as 01 NJDEP GEO website, imagery infrared 2015, wetlands 2012. In looking at it, are you able to identify the subject property? And there's no north arrow on this, but it identifies Lot 11C, Block 410, Lot 31, Block 410, and I believe it's Lot 30 right to the left is that. Now, I'm not putting forth the proposition that in fact wetlands are on this property, but does not this DEP exhibit indicate to the reader that there's the possibility of wetlands being on the subject property?
So the short answer to your question is these are generalized DEP maps which show where there's a possibility that there are wetlands, and indeed they're shown on a portion of the lots that you described. But from a planning standpoint, in terms of determining wetlands, they have to be surveyed, field delineated, and subject to a letter of interpretation from the DEP. These are just generalized maps that indicate the possibility of wetlands.
I think I said that. But having said that, do you know whether or not...
And I'm confirming what you said.
Thank you. I appreciate. Great minds think alike. Having said that, do you know whether or not this applicant, either as an applicant or his engineers, ever made any attempt to determine whether or not there are wetlands on this property?
You'll have to ask the site engineer. I did not do that.
Okay, fine. And you've never seen any materials produced to you by the applicant to indicate whether he did or he didn't?
Correct.
Did you review all of the plans that were submitted with this application?
I did.
Did you make any observation on them as to whether or not there was any attempt to make a determination as to the presence or lack of presence of wetlands?
The reviewing the plans wouldn't allow me to answer that question. The plans are the plans. They speak for themselves.
Okay. Do you acknowledge the fact that in the prior approval for the nursing home, there were in fact wetlands on that property and were delineated on the plan?
Again, I did not review the plan. I reviewed just the resolution of approval.
I have no further questions.
Okay. Ms. Short, so now we finish that, we go to Mr. Tautner's cross or the impact?
I think so. Well, he's going to go to the fiscal impact,
Okay.
I think, right?
I'm sorry, I didn't
You're
hear.
you're going to be now questioning your witness as to the fiscal
Fiscal
impact
impact.
statement, right?
So, yeah, we,
Which is fine if you want to do that now, so that if there's any additional cross, that could be concluded before we go to your cross and rebuttal.
why don't we do that now? That would be great.
And let's do that now. Before we do that, just one housekeeping. Mr. Gazarovski, you're complete with your cross-examination for the moment. Is that correct?
That is correct.
Thank you. Okay.
Actually, Madam Chairman, after further consideration, actually, we're gonna waive or decline to do what we suggested in the beginning of the hearing. We'll just move forward and
To the
not
cross.
have further questions for Mr. Phillips.
Okay.
Having said that, is he going to have any questions of any other of his witnesses, or that would conclude his case, would it not?
He's entitled to cross-examine your witnesses and to provide...
understand that.
And to provide rebuttal testimony.
Okay. Mr. Steck is here.
So we would seek to cross-examine. By the way, does that conclude the objector's direct case in terms of, you don't have any additional witnesses?
Mr. Tautner, please, you're going
Oh,
to
I'm
have to
sorry.
speak into the
I
mic.
just wanted to
Yep.
confirm that the objector's case has been concluded in a direct capacity in terms of there's no additional objector witnesses that would be presented.
I think there are other objector witnesses which are part of the public, but they are not part of my case, nor are they represented by me.
Okay, that's what I wanted to confirm. All right, so with that, we would seek to cross-examine Mr. Steck and Mr. Litwarnia.
Who do you want first?
We could do Mr. Steck first. If that
Okay,
makes
Mr.
sense.
Steck, would you raise your right hand? Do you solemnly swear or affirm to tell the whole truth, nothing but the truth, so help you God?
I do.
And please state your full name for the record.
Peter G. Steck, S-T-E-C-K.
Thank you.
Mr. Steck, you testified previously that, I'm sorry, I believe you testified previously you were present for 2 of the hearings that were conducted in conjunction with this application. Is that correct?
At least 2 of them, yes.
Yeah. Which 2 hearings did you attend?
I don't recall right away, but I know that I did also read the transcript of Mr. Phillips's testimony.
Okay. And did you, with respect to the hearings you did not attend, did you review the transcript or review the video recordings of those meetings?
I can't tell you exactly. I think I've been to here, 4 times, and I think I have been present or read the the transcript of the hearing I was not at.
Okay, now, you were qualified before this board as a professional planner, correct?
Yes,
Okay, and you have not been qualified as a professional civil engineer, correct?
that's correct.
Okay, and you have not been qualified as an environmental scientist, correct?
Correct.
Okay. Now, as a professional planner, do you agree that an assisted living facility is an inherently beneficial use?
Yes,
Okay. Now, would you also agree that there is a specific housing recommendation in the master plan and in the master plan reexamination report to encourage the development of a creative senior citizen housing option such as an assisted living facility and active adult market housing to accommodate an aging population?
there's a general goal that applies to the entire municipality, but there are obviously more specific recommendations in the master plan that happen not to be referenced by Mr. Phillips.
Okay. Now, is it true that the master plan states that the township should amend its zoning ordinance to permit options such as an assisted living facility as of right?
It was a recommendation of the planning board, which was apparently not followed, not agreed to by the governing body, because they did not change the zoning ordinance as a result of those master plan recommendations.
No further questions of Mr. Steck.
Okay.
Your next witness, Mr. Litwarnia.
Madam Chairman, let me just get a clarification as to the cross-examination of Mr. Litwarnia. I think he was cross-examined, and then he subsequently submitted a report. So are there any limitations to the cross, or whatever he asks is okay?
No, whatever asked is not okay. Obviously, there is a new report, so I will have them question on that report and any other cross-examination that they haven't completed because they were only partway through.
Well, can we attempt to determine what differences there are in the report compared to any previous testimony?
I'm not restricting them, Mr. Gazarovski,
Okay,
to the
fine.
report. A lot of latitude has been accorded the objector's attorney
fine.
as yourself. So
Let's
I'm
go.
going to allow him to proceed and see where we're at.
I don't want to argue, but
Okay?
let's go forward.
Okay, so I'm not trying to argue. Can we please have?
I know you're not.
Can we please have Mr. Litwarnia have a microphone? Sir, would you raise your right hand? Do you solemnly swear or affirm to tell the whole truth, nothing but the truth, so help you God?
Yes, I do.
And please state your full name for the record.
Alexander J. Litwarnia,
Thank you.
Litwornia.
So, Mr. Litwarnia, in the bio that's included with your report, the bio states that you are a certified noise analyst, correct?
Correct.
Okay. Now, that's not a certification that's recognized by the state of New Jersey qualifying you as an expert in acoustic evaluation, correct?
No.
You don't have a microphone, Mr. Gazarovski?
Acoustics is different than noise. They're two different disciplines.
I believe he answered the question that having a certified noise analyst listed in his bio does not qualify as a certification recognized by the state of New Jersey as qualifying him as an expert in acoustics evaluation. He answered yes. I don't understand the basis of the objection.
I'm not sure I understand the objection either, because your objection didn't match the question and the answer. So I'm not sure I understand it either, Mr. Gazarovski. Do we have another microphone for Mr. Gazarovski to use? Why don't we hand him that microphone over there? No, he has, there's one for Mr. Litwarnia's. If there's another microphone, because we're going back and forth, it would be just more expedient.
Thank you. Let him go on with his cross-examination, and we'll get through this.
Okay.
Now, in terms of being a certified noise analyst, that's a certification as a noise control officer for a municipality? Is that what that is?
Well, basically, you could take a course at Rutgers University.
Can you speak up, sir? I'm having a difficult time
Basically-
hearing you, so that they probably can't hear you for the filming.
Is this okay now?
Yes, much better, thank you.
Thank you. Basically, you could take a course at Rutgers University to become a certified noise analyst, which allows you to go out and take noise readings and enforce noise codes throughout the state of New Jersey. I have done and been accepted as a noise expert at courts and worked on noise studies from airports for housing, and including noise studies for the Concord jet landing in Kennedy Airport. Done noise studies for various different locations and noise walls, and installed noise walls for Burlington County. So, and I've been qualified as a noise expert before courts as well as other planning boards, and worked as a noise analyst for Mount Laurel Township, Hamilton Township, City of Absecon, and other townships in the past, and been accepted as a noise expert as a professional engineer working in that discipline.
Mr. Litwarnia, when you say you've been qualified as a noise expert, is that the same as being qualified as an expert in acoustics?
An expert in what?
Acoustics?
Well, I've been accepted as a noise expert in noise on site plans, and I did not get into internal acoustics, but have been worked and accepted expert in noise and acoustics exterior to buildings, not interior. We've never done interior noise analyses, just exterior.
Now, your bio indicates under your professional certifications that you're a professional engineer. Is that correct?
Yes, I am a professional engineer, yes.
Okay. And is it your testimony that in your field of work as a civil engineer that you've concentrated in acoustics?
No. As a noise expert on various projects, I've been a civil engineer in various projects as well. Now, if you're bringing it up, I've been in an area where I've designed shopping centers, Burger Kings. Our firm won an award for the best redesign of Burger King with the improved circulation, etc. We've also done site plans for shopping centers, for Burger Kings, for primarily some of these smaller commercial facilities as well as some of the larger ones.
But it's your testimony that you have prepared noise impact studies in conjunction with projects that you've worked on, similar to what you've just described?
I have prepared noise studies and analyses for projects similar to this, dealing with loading, truck loading and unloading zones, garbage trucks, loadings at ShopRites and other food stores, and handle complaints for Burlington County when I worked in special projects person at Burlington County, where I was also the transportation engineer for Burlington County, as well as the other duties there, which was a special project.
Now, that information is not contained in your bio, though, correct?
Excuse me?
That information, that work that you allege you've performed in terms of having prepared noise impact studies, that's not identified in your bio that's attached to your report, is it?
No, not everything is in my report. I mean, I've been a professional engineer in the state of New Jersey for over 30 years, represented municipalities, the counties, and was a director of planning and transportation at Tri-State Regional Planning Commission, and worked there for over 12 years. So I have a background that I didn't put everything in the world in. I don't know if it has some of the things in there that I've done or not, but I could elaborate on some if you wanted me to keep on going into it.
Well, let me ask you a question. Have you previously in your experience as a professional engineer ever analyzed traffic generation for an assisted living facility prior to this application?
Have I analyzed traffic studies?
Traffic generation.
Traffic generation? I haven't analyzed traffic generation in my office since this afternoon. I think this is getting ridiculous. I've been a traffic consultant for...
Please, Mr. LaGuardia, regardless of what your personal feelings may be, just respond to the question, because if you answer otherwise, I don't want to insult the board, and they don't want to hear you complain. So just answer the question.
Well, can you
repeat the question, please?
Sure, I can repeat the question. Have you, prior to this application, previously analyzed as part of your work as a engineer traffic generation for assisted living facilities?
That's a good question, and I can answer that with fun. The first book that was called Trip Generation was put out by the Institute of Transportation Engineers. And what it did is took all the different studies from different municipalities and traffic engineers and consultants and put them together to come up with a series of formula to determine what the generation would be as a function of square footage or employees or area, and it was the national standard in the United States. That first book was written while I was a Director of Transportation at Tri-State Regional Commission, Tri-State Regional Planning Commission, and the person that wrote the book worked for me, and I worked with him on that book, which is called Traffic Generation, Trip Generation. So yes, I'm familiar with trip generation, and I've worked on it previously.
Mr. LaGuardia, with all due respect, I think the board is entitled to hear the answer to the question. Can you please have that question repeated? It is an important question.
The answer is yes, I've worked with trip generation.
With respect to assisted living facilities prior to this application, that was the rest of the question.
Yes, I worked with trip generation prior to this application.
With respect to
before.
assisted living facilities, correct?
Excuse me?
With respect to assisted living facilities prior to this application?
Yes.
Okay. Sir?
Can you give me an example of assisted living facility for which you, prior to this application, prepared to analyze traffic generation?
I don't have them on the tip of my tongue, but I can give you a list if that's what you want.
Well, why don't we move on? So, in your prior testimony, you didn't discuss the intersection of Old Raritan Road and Inman Avenue, correct? When you previously testified before the board, you didn't provide any testimony regarding the intersection of Old Raritan Road and Inman Avenue, is that correct?
What I did was I mentioned that there was no analysis performed at the intersection of Inman Avenue and Railway Road, I guess it was Old Railway Road. I'm trying to think of the name of those. Ingman and Tingley Lane. There was no analysis done there by the school, or further to the west at the T intersection. And those were the two key intersections that would be impacted by this facility.
Well, with respect to Old Raritan Road and Inman Avenue, in your report that you submitted to the board, you stated that the intersection is known to have peak hour delays, and although it is the closest intersection to the west, it was not reviewed. Is that correct?
Correct.
Okay. Now, did you review that intersection regarding peak hour delays?
No, I did not analyze that and take counts on it.
Okay. Now, the 2003 master plan for the borough considers the condition of the intersection of Inman Avenue and Old Raritan Road and states that that intersection is a low priority for the township. Is that correct?
I'm not positive.
Okay. Now, were you present when Mr. Desario testified regarding the ITE-based traffic generation for an assisted living facility?
Yes.
And you were also present when he testified regarding CARES 1's experience factor regarding trip generation?
Yes.
Okay. And were you present when Mr. Desario testified regarding his traffic counts and observations that the assisted living facility would add only one car every 6 or 7 minutes towards the intersection of Old Raritan Road and Inman Avenue during peak traffic periods?
Yes.
Okay. Now, you make the statement that the backups at the intersection at Tingley Lane and Inman went into gridlock during peak hour. Is that correct?
I said when the school gets out. And
Yeah.
basically, as I recall, the peak hour was not analyzed when the school traffic exited because that wasn't counted or looked at.
You would agree that your report, however, doesn't provide any empirical data to support a statement that there's gridlock. Is that correct?
I don't believe so. I think I said it fails, and it works as a level of service F from my observations. And level of service F means that the intersection is blocked, and it's blocked from cues from two or three directions. There's only 3 directions you can approach it, and all 3 were blocked at various times.
But you're assigning that level of service F. You didn't provide empirical data in your report to support that conclusion that you're now stating, did you?
I was there and observed it.
Okay, now, you stated that any additional traffic from the CARE 1 facility will severely impact the intersection of Inman and Tingley, and that the adjacent intersection of Tingley and Rahway Road. But again, fair to say that the report doesn't set forth any empirical data to support those conclusions?
Well, basically, if you took a traffic count, it wouldn't do anything at that intersection to show what level of service it's operating at. And for example, if you had an intersection that had 100 cars approaching it in an hour and going through it in an hour, and it would come out with a level of service A, and then you took the same intersection and it was backed up, and because the queues, only 100 cars could get through, it would still show as a level of service A, even though it showed that that level of service A was failing, and it was only working at 100 cars getting through just because of the fact that that was limited by the queue upstream. So you can't really look at that intersection and run it and come up with a good level of service. It's going to show as a failure just from the observation. So basically, since it's going to be a failing system, you have to perform gap studies to show if this intersection would be able to accept additional traffic volumes without a detrimental effect, and it wouldn't.
But fair to say you're not providing empirical data in your report to support those conclusions. You're basically offering the conclusion and stating, I was at these intersections, I observed it, and this is my conclusion based on what I observed without empirical data being provided. Is that correct?
Not completely. I also observed it, and I also read the analysis from Edison Township's board reviewer, who said that the town, they should look at the traffic volumes during school hours because that was the peak hour as opposed to the peak hour that was looked at by the applicant.
On that subject, now, your report doesn't contain any empirical data demonstrating that the few trips generated by the facility would contribute to traffic as a result of school dismissal occurring at approximately 2:30, is that correct?
It was, I said approximately at that time, 2:30 to 3:15 in that time frame.
But again, you've offered a conclusion, but your report doesn't contain empirical data to demonstrate that conclusion,
It's
correct?
been asked and answered a half a dozen times.
Actually, it has not. I'm still waiting for the answer. Was there empirical data? It's the same
think I
question he's
answered it
asked four
before. The
different
only-
ways.
I think I answered it.
I'm sorry. It's the same question he's asked 4 different ways, and I'm still waiting for an answer on whether or not there was empirical data.
A yes or no?
I
Please.
did not do traffic counts. I looked at the intersection, observed it, and by observing it, I could tell it was a level of service F and it was failing.
Okay, you have your answer. Let's move
Thank
on.
you.
Thank you.
So you've referenced the intersection of Inman Avenue and Tingley Lane and Inman and Rahway Road. That intersection is in fact about a half a mile from the proposed facility driveway. Is that correct?
It's probably close to that.
Okay. I actually don't have any further questions, but would like to call rebuttal witnesses.
Okay. Thank you, Mr. Litwarnia. Who's your first rebuttal witness?
Sure. Mr. Matthew Morello.
We need the microphone. Wait, it's over
Yep,
there. You
it's
have to
over there.
get it from Mr. Litwarnia or Mr. Gazarovski. Thank you.
It's musical microphones instead of musical chairs.
Throw them back and forth.
Yeah.
Would you raise your right hand? Do you solemnly swear or affirm to tell the whole truth, nothing but the truth, so help you God?
I do.
Okay, and state your full name for the record, please.
My name is Matthew Murello, M-U-R-E-L-L-O. I'm president of Lewis S. Goodfriend and Associates. I provided testimony on acoustics and noise before.
Madam Chair Lady, before we proceed, Mr. Litwarnia was cross-examined as to his report. I don't believe the report, although submitted to the board, was ever marked. So can we mark that as O2?
Mr. Litwarnia's report, we can mark that as O2. The board does have it, Mr. Gazarovski.
I understand that.
Okay.
And Madam Chairman,
yes,
with your permission, we'd
Yes, please.
like to mark as Exhibit A45 a CV for Mr. Morello.
Okay.
By my approach.
Oh, okay. Okay, let's see, that was 8:45. Here, send it down, look at it, send it. His qualifications are okay. Mr. Morello, just for the record, please, let's have your qualifications. Even though we have it here, it should be verbal.
Certainly. I have a Bachelor's of Science in Mechanical Engineering with an emphasis in acoustics from the University of Hartford. I'm a licensed professional engineer in the state of New Jersey and 6 other states. I provided expert witness testimony on over 200 occasions in municipalities, courts, as well as citing councils in other states as well as New Jersey. I'm currently the president of Lewis S. Goodfriend and Associates, where I've been for 24 years.
Okay, thank you. We'll accept your qualifications, sir.
Thank you.
Thank you. Now, Mr. Morello, you were present when Mr. Litwarnia provided his testimony to the board a few moments ago, and have you had an opportunity to review Mr. Litwarnia's report, which has now been marked as O2?
I have.
Okay. Now, in that report, Mr. Litwarnia makes statements regarding noise generation from trucks and Care One's proposed emergency generator. Is that correct?
Yes.
Okay. Now, have you had an opportunity to analyze those statements from the standpoint of your expertise with acoustics?
Yes, I have.
And can you offer your opinion in terms of rebuttal to
Sure.
the conclusions expressed by Mr. Litwarnia?
I will. In reference, this is Exhibit 02 is Mr. Litwarnia's October 1st, 2019 letter. Page 3, Mr. Litwarnia has a couple of paragraphs on noise impacts. And I will the first statement he makes, he says that the specification of the generator was 70 dBA at 21 feet. He stated, quote, "I had listened to the noise testimony from the applicant's expert." Just want to point out that my report did state that that was the initial noise specification, but I did state in my April 24th testimony, April 23rd testimony, that the manufacturer had come back with a quieter enclosure, 5 decibels quieter than what it says in our report. So just nothing of a clarification. And I agree with Mr. Litwarnia's statement when he says that we will comply with the daytime limits of the code, which I did testify to. Mr. Litwarnia also indicated in his letter that the octave band sound pressure levels, or the spectrum, the different frequencies, was not evaluated, when in fact we did. In my report, and forgive me, I don't know what the exhibit number was because we're in the 40s somewhere, but January 2nd, 2018 report from Lewis S. Goodfriend and Associates, my report. There are 2 figures at the end of that report that show the octave band sound pressure level analysis and how it complies with the daytime code. My testimony was limited, just for simplistic reasons, to the overall 8-weighted sound levels, but we did prepare that report and we did complete that analysis. The second piece to Mr. Litwarnia's testimony was with reference to trucks. Overall, we've testified that we would, if a condition of approval were made to do post-installation noise measurements at the residential property lines, we would comply with that. Any and all operations related to the site, including trash deliveries, generator operation, mechanical unit noise, we would comply with that, which is overall what Mr. Litwarnia's final conclusion was, that we would do something like that. He does state in here that some truck noise, in his opinion, would exceed the regulation at 50 feet if a trash truck was to operate in the vicinity of the eastern property line, about 50 to 75 feet away. He doesn't state any reference to where he gets these numbers, and my opinion is that he references 80 dBA from a truck idling at 50 feet, and I find that to be much higher than what the Federal Highway Administration or the Transportation Noise Model, which are federal standards for truck noise, which are typically between 65 and 70 dBA. But with our conclusions and based upon the analysis that I've presented already, I believe that any truck traffic during the daytime hours, including backup alarms and trash removal, will comply with the daytime limits of the regulation. That summarizes my comments on Mr. Litwarnia's noise letter.
No further questions. Although we have another rebuttal witness. But
Okay, one moment.
sure.
Did you have any redirect on that?
I have some questions.
I'm sorry?
I do have some questions.
Okay, we're going to do that now.
Okay, Mr. Rella, I already introduced myself, and I, of course, represent several of the objectors to this matter. Now, would you agree with me that there is, in fact, a distinction between the science of acoustics as well as simply the study of the sound of noise?
For me, it's potato.
Pardon
Noise
me?
is just unwanted sound, which is all acoustics. Acoustics is just the engineering science. Noise is just unwanted sound.
Noise is unwanted sound. And in order to qualify as a person qualified to testify as to noise, one doesn't have to have a college degree, does one?
And that's a recommendation that I would think council, the board would have to make if they deem an expert to be an expert, far be it from me.
Okay, you're aware of the fact, are you not, that the state of New Jersey does in fact offer courses at Rutgers where one can qualify as one who is able to measure sound and give testimony with regard to it, also to serve as a code enforcement officer when those noise limits are violated?
I'll agree with one part of that. Yes, they do offer a course for someone to make measurements and enforce the code. The rest of it is no, that is not offered in that
Okay,
course.
have you ever taken that course?
Absolutely not.
Okay.
I'm not a code enforcement officer.
Well, you never received no type of certification that would permit you to testify with regard to measuring noise or unwanted noise.
No, that's not true. I haven't taken the course to become a noise control officer and work for a municipality or the county. I have, however, do have a 4-year degree undergraduate in acoustics, which I do believe it qualifies me to be an expert.
Okay, my understanding of noises is that the most commonplace way to do it is to use some form of a computer that would measure noise at various distances, correct? Or you could also do it through a computer program, which I believe is manufactured in Germany.
No. We have modern instrumentation that can measure sound without computers.
I just said there is in fact a device that can measure sound or noise without a computer, correct?
Well, I don't believe that is what you said, but yes, there are sound level meters, and they are manufactured in other places other than Germany.
I
but
didn't
that
say
can
the
measure-
meters were manufactured in Germany. I said the computer model was manufactured in Germany. But let's skip all of that. There is, in fact, a noise meter which is commonly utilized by code enforcement officers throughout the state to measure noise. Am I correct in saying that?
There are several types, yes.
Okay. Am I correct in saying that there are two different standards for measuring noise? One being noise measured during daytime hours, which I believe is 65 dBAs, and the second being noise measured in the evening hours, which I believe is 50 dBAs.
With respect to the DEP, yes.
Yes, okay. Well, it's also incorporated into all of the municipalities throughout the state, is it not?
Several, yes.
Okay, well, one or two or hundreds?
I have no idea, but
Okay, fine. Now,
Mr.
measuring
Gazarovski,
noise.
excuse me, Mr. Gazarovski, if you could just wait, I think our transcriber needs to be able to hear both of you. So before you start, maybe you should let him finish, and before, you go to your next question.
I understand
okay?
that. Now, my understanding is that measuring noise with a noise meter is a relatively simple procedure. Am I correct in saying that?
simply making a noise measurement, yes. But
Yeah.
I guess complying with the DEP code must not be in order to take an 8-hour course in how to do it.
What I'm asking you is that there is such a device known as a noise meter or a sound meter, correct?
Yes, I've answered that.
And it's relatively simple to operate that particular device, correct?
Yes.
Now, with regard to measuring noise, as to this, as for example, with regard to truck noise, one can simply measure truck noise by having a truck present perhaps in a parking lot or a parking site, start the engine up, and then while the engine starts and it's turning over, you can place the meter at various distances away from the truck to measure the noise. And you also have to take into consideration the ambient sound.
Yes.
Okay. Now, with regard to this application and this testimony, did you do that?
No.
Now, there are also charts, are there not, which is put out by the DEP that gives you approximations of measuring sound from trucks which you can consult. Prior to your coming here this evening and giving testimony as you have, did you consult those charts in preparation for this testimony?
For the DEP, no, there are no such things.
Okay. Now, let's talk just briefly about the evening hours. In the evening hours, the maximum permitted sound is 50 dBAs, correct?
At the residential property line, yes.
At the residential property line. Not at the house, but at the residential property line itself. So did you make any determination as to what the distance was between the refuse collector where the trucks would be to the residential property line? I'm not asking you to look at your notes. I'm asking you whether you did that test.
Mr. Gazarovski, he can refer to what he needs to answer your question. The board needs to have enough information. If you've asked the question, give him an opportunity to answer it.
Okay, I apologize.
I might also object here. Some of these questions are exceeding the scope of the cross-examination of Mr. Litwarnia and certainly the contents of Mr. Litwarnia's report. I didn't think we were reopening the entirety of
We're
cross-examination for
not.
Mr. Morello.
We're not. I've given him some latitude as I've given the applicant some latitude, but that's coming to an end shortly.
The distance from the closest point from the refuse to the property line is about 50 to 55 feet.
Okay, fine. Now, in preparation for your testimony for this hearing, did you ever conduct measurements as to that distance and the type of truck that would be for a refuse collector truck?
I'm confused. Measurements, there are no trucks on that site currently, so it's difficult to measure it.
Well, I know there's no trucks on the site because there's no parking lot, there's no parking area, there's no driveway, but you could drive a truck onto the middle of any parking area and conduct those exact tests, can't you?
I'm going to object again where...
Sustained.
I'm finishing up.
Let's move on. Mr. Gazarovski, let's not talk about hypotheticals. Let's talk about concrete questions as to what
All right,
this
is all-
gentleman has testified
fine.
about.
Now, there's an adjacent nursing home to the subject site, which is to be incorporated into this, is there not? You could have performed that test there.
Objection.
Let me move on. Two or three final questions. You gave testimony with regard to the early part of Mr. Litwarnia's report, speaking about proposed HVAC equipment and the like. Now,
Objection.
No, he did not.
pardon me?
He did not.
He questioned him with regard to the first part of the noise testimony dealing with proposed generator, and I thought he said, and I'll stand corrected, that he had received some further information from the manufacturer that clarified that, but I've never seen a copy of that report. I've never seen a copy of his supplemental report, despite the fact we made an OPA request.
Mr. Morello?
Yep. All I did was respond to Mr. Litwarnia's statement when he said in his report that he had listened to my testimony and that I had stated that the generator was going to be 70 dBA at 21 feet. My comment to that was in my testimony, I stated that we developed a specification of 70 dBA, and that's what we recommended. The manufacturer came back after our report was generated and said that they were going to provide a generator enclosure of 65 dBA, about 5 decibels quieter. That's the generator.
Do you have that report to present to the board?
It is my court report from Tuesday, April 23rd, 2019, page 74, lines 11 through 18.
That sets forth a copy of a report?
No. My report indicated that it was 70 dBA was our recommendation. The manufacturer then came out and provided the client with a specification of 65 dBA, which was 5 decibels quieter. It is not in my report, it was in my testimony.
And Mr. Morello, we do have a copy of that report that has been given in, and
Okay.
the board has,
Thank you.
correct?
Thank you, Madam Chair, I
Thank
believe
you.
so. My report, yes, was provided to the board.
Yes.
I didn't receive it. We opened it. But let's go beyond that. I don't want to get into that argument. With regard to this issue of the location of the generator, did you make any analysis of any noise which would be generated by the HVAC units on top of the facility?
No.
Other than the refuse collection facility as well as the generator, are there any other noise-generating creators on that side of the building adjacent to the residential homes?
Madam Chairman, I'm going to object again. We're exceeding the scope of the cross-examination and the rebuttal testimony.
We're not going to rehash testimony
You know,
that's already been provided. We understand, the board has heard testimony. We have days and days of testimony, so this has already been testified.
I have no further questions.
Thank you.
Okay, for this young lady to have her rest her hands, I think we're going to take a 5-minute break. I don't want anybody to go too far, because in 5 minutes, I want everybody back here, please.
Thank you, Madam Chairman.
So we'll take a break for 5. Okay, guys, are we ready? Okay, everyone, I'm going to go back on record. Okay, we're back on record. Mr. Traubner?
Thank you, Madam Chairman. So our
Okay, excuse me, we're back on record. Thank you. Okay, Mr. Traubner?
Certainly. So for our final rebuttal witness, we have Dan Desario, who I believe was previously testified in this matter. Mr. Desario, if the board's preference, we could have him re-sworn.
Thank you. Raise your right hand. Do you solemnly swear or affirm to tell the whole truth, nothing but the truth, so help you God?
I do.
And please state your full name for the record.
Certainly Dan. Last name is Disario.
Now, Mr. Desario, have you had an opportunity to review Mr. Litwarnia's report that was marked as 02 this evening?
Yes.
And you had an opportunity to listen to Mr. Litwarnia's testimony this evening?
Yes.
Could you, in reviewing that report and in listening to the testimony this evening, have you developed any opinions regarding the subject of Mr. Litwarnia's testimony and the subject matter of his report as it relates to traffic?
Yes.
Yes, and could you give the board the benefit of those conclusions?
Object to the form of the question. It's speculative. It's not a question. This is supposedly rebuttal.
I don't, it's speculative, okay, that's interesting. So, Mr. Desario, you've reviewed Mr. Litwarnia's report, correct?
Yes.
And you listened to his testimony this evening?
Yes.
And based upon your review of his report and your listening to his testimony, have you formulated any opinions regarding the subject matter of Mr. Litwarnia's opinions as to traffic?
Yes.
Could you give the board the benefit of those opinions?
Certainly, and that will be brief, and it will focus essentially on two aspects. The first one being site triangle at the proposed driveway. The objectors have spent a lot of time in terms of testimony, as well in Exhibit 02, discussing concerns relative to site distance and site triangles. And I want the board to be clear in its understanding that the site triangles as proposed are shown on the site plan. They are shaded triangles. They're easily seen if you review the plans. And those physical site triangles do not change in terms of dimensions if indeed the county requires a dedication across the site frontage. The site triangles stay exactly the same in terms of their dimensions. The only thing that would change is that the site triangle would move back into the site by whatever distance Inman Avenue would be widened. So as an example, today, if this project were built and you were driving out of the proposed driveway, you would come to a stop at the existing edge of pavement. You would look to your left and you look to your right, and we would provide the site triangles that are required so that you would have a clear sight distance looking left or right. If the road were ever widened, let's say by 12 feet, to provide another travel lane along Inman, you would simply, in the future with that widening, have to stop 12 feet back from the existing edge of pavement because...
But, Madam Chair, I'm going to object. This is just a
He's
net...
answering a
It's
question.
not a net opinion.
Mr. Gazarovski?
Pardon me?
This is rebuttal. Let him
It may be
have...
rebuttal, but rebuttal just can't be speculative. He can't testify about something that he's never done. He hasn't prepared such a report. He hasn't prepared such dimensions.
Gazarovski-
It's a blanket net opinion.
Sir, I could have also stopped your witnesses from testifying or your questioning as to speculative and hypothetical matters. So that happened throughout. In fact, I am directing the board, if there were any hypothetical issues that were raised, then I would suggest that you do not consider hypotheticals that have not happened. So if there is ultimately a taking, there might be a taking, but that's not the application before you. We're going to let him continue with his testimony.
Thank you, Ms. Shaw.
Thank you. And as I was saying, if the road were ever widened, you would just stop it. As an example, if the road were widened by 12 feet, you would just stop 12 feet further back than you would today in terms of the existing pavement edge. So regardless if there's a county dedication, the right-of-way line would just move. The site triangles wouldn't change. The site triangle would change in terms of its reference point if the road were widened. So the site triangle would have to move back into the site in a northerly direction if the roadway were to be widened. If you look at the site plans, the site and the frontage along the site could accommodate a change in the position of the site triangle if the road were ever to be widened. So this board can feel comfortable approving this application as it relates to site triangles and site distance, because whatever would happen with the road in terms of a widening, the site could provide an adequate site triangle because there's enough frontage to accommodate those site triangles. Mr. Warner's report, as well as his testimony, touched upon some off-site intersections, and you heard that testimony this evening. 02, Mr. Warner's report, makes reference to a publication that's widely known. It's indicated on page 2 of his report, Transportation Impact Analyses for Site Development, Institute of Transportation Engineers, a recommended practice 2010. In that publication, there is a suggestion that is made that for land developments that generate less than 100 additional peak hour trips, that a traffic impact study should not necessarily be required. In Mr. Litwarnia's report, he identifies the maximum peak hour trip generation of the proposal before this board as being 38 peak hour trips. I would respectfully submit to the board that level of traffic generation is not significant as it relates to traffic impacts at off-site intersections, and because of that, does not rise to the need of looking at traffic impacts at off-site intersections. And with that, I conclude my rebuttal testimony.
All right, any process to the rebuttal? And please, let's keep it to the rebuttal this time.
Mr. Desario, I've listened to your testimony concerning the issue of the site triangles. Now, you were retained to prepare a report with regard to the impact of traffic as well as the safety of traffic ingressing and egressing from the site, were you not?
As it relates to traffic operations, yes.
Yeah, and when you prepared this report, you were aware of the fact that with regard to the property immediately to the right as well as property immediately to the left, the county and or the municipality had called for a road widening.
I was not aware of that, no.
You were not aware of that?
No, sir.
Okay. Are you aware of it now?
Yes.
Okay. Being made of it where it now, is it safe to say that when this matter goes before the county, they will similarly call for a road widening?
I do not know that to be the case.
Okay, Mr. Gazarovski, that was asked, I can't tell you how many times tonight, and answered how many times tonight, so let's move
You
on,
know,
please.
first of all,
Mr. Gazarovski.
First of all,
Mr.
respectfully,
Gazarovski,
he-
hold on,
Gazarovski.
please. It was also asked previously.
he has testified, he has
let me-
testified, okay, I'm sorry, go ahead.
One person at a time, and please respect this board and our attorney.
Okay.
I shall.
That line of questioning was already conducted in prior hearings on this matter. Again, I'm directing the board, if there's a hypothetical situation, you're considering this application the way it stands today. So that is what we're going to do. Let's focus on the rebuttal. His rebuttal has to do with responding to Mr. Litwarnia's report, which is really what his rebuttal covered 2 points. So let's focus on those.
You've listened to testimony from this witness saying that if in fact the road were to be widened, that the site triangle distances or dimensions would be exactly the same. That is something no more than a net opinion by him. And he's testified that prior to his preparing his initial report, he was unaware of the fact that the county had required road widening on the adjacent parcels. I find that to be incredulous. Having said that, all of his testimony with regard to what he's just stated in rebuttal as to the safety of the ingress and the egress and the site distances should be stricken.
Okay, you can save that for summation, but I'm not inclined to strike anyone's testimony with either side, simply because the board has to have the benefit of all testimony to make a decision as to what the board finds relevant in making a decision. Okay? Any other questions?
No further questions?
Thank you.
Okay, so at this point,
Are we done? We did all the
I think we better
rebuttal?
ask both sides.
Okay.
Put it on the record.
Mr. Troutner, are we done? Mr. Troutner? Are we done?
I'm sorry, I'm just, my apologies, I'm just confirming, but yes, I believe we are complete.
Okay, Mr. Gazarovski, we're
I'm
done.
done.
Okay, we have now finished both sides. In lieu of the fact that it's 9:24, and I know the public wants to speak, and also in lieu of the fact that I have noticed that quite a few of the public have left, I will not go out to the public because, number one, it will be late, but number two, it's not fair to them because they have been here and they have now left, figuring that it was going to be this late and we wouldn't get to them. So we will have Cassandra tell us the next meeting. We will not have any more testimony. That meeting will be strictly for public input, and hopefully we'll have a full complement and a vote. Although we never know in this world, because there are people that do get emergencies, but usually we do have a full complement, and that is the agenda going forward. So having said that, Cassandra, when is the next available date for all of the public input?
December 17th.
Okay, so has everyone heard that? It will be December the 17th. It will be for the public, and it will go for a vote, okay? And I have to thank you very, very much for being patient. It's been a marathon. We're coming down to the final line, and all I can say is thank you for being patient, and take care. Cassandra, do we have some resolutions?
Yes, there's 5 resolutions to be adopted. The first one is Z39, 2019, Shaylesh Shaw, granted. Z37, 2019, Gerald Vince, granted. Z38, 2019, Purvi Parikh, granted. Z4, 2019, K&K Melbloom, granted. And the last one is Z42, 2019, Katie Singh Enterprises, granted.
Do I have a motion to approve?
Motion to accept.
Second?
Second.
All in favor?
Aye.
Okay.
Motion to adjourn.
Second?
Second.
All in favor?
Aye.
Thank you. Good night. Appreciate your patience.